So now this is the first change which has taken place. It's very important is on the cartels. Horizontal anti-competitive agreement. They have widened the net to include facilitators or hubs other than direct competitors in cartels and anti-competitive agreement, even non-participants. So what is a cartel basically? I hope most of the participants here who joined understand. So as a direct competitor, you're not supposed to be talking to each other on business term. You're not supposed to be talking about the prices which you're going to give to the customer, your capacities, your future business plans, things like that. You should not exchange information with them. No, there should be a degree of uncertainty into the market. That is what competition is all about. So if I know what my other lawyer colleague is charging a client, then I will be tempted to fix that price. I'll say I'll give you उससे थोड़ा कम दे दूंगा मैं आपको. Then I'll take the client away. So that thing never happens, because if that happens, that you're destroying competition. So in the competition, the choice should be with the client or with the customer, not with the supplier. That's what a competition basic fundamental is. But with the cartels, what happens is that the prices are fixed. Not only prices are fixed, the quantities are also, sometimes fixed, that we'll give this much to, and the markets are divided, like we saw the cement cartel. So those actually issues have now been broadened. Earlier it was directly between the competitors. 3.3 wanted to say that the agreement should be between the direct competitors, then only it will be a cartel or an anti-cartel. But now what has happened is, it is including facilitators. You are not a in the same line of business, right? I'll give you an example of a trade association. Now, trade association need to be very careful. So, trade association is a body of those people who are competitors. But trade association itself is not a body. It itself is not in the same business, right? But could it be considered as a facilitator? So that is the moot question. When it will be considered as a facilitator, that has been provided now. Earlier there was ambiguity on this. So CCI, for example, just give example, not that I'm saying that every trade association is bad. It was being considered a plus factor. So if you are meeting in trade associations, and if you are competitive, suppose you are steel makers, suppose you are plastic manufacturers, suppose you are a printer, for example, and you are meeting in trade association. So that meeting itself was considered in some cases as a plus factor for a cartel, that you are actually colluding, you are having connivance with each other, because it is a platform you are getting where you can meet. Otherwise, if you meet otherwise, then of course there's a direct evidence. If competitors meet in a hotel before says putting the bids, it is obviously direct evidence, because it will at least show that there was a meeting of mind. But if suppose they meet at a trade association, then will it be considered as a plus factor or not? So now what the government has done is, please read the second bullet, facilitator of cartel to be presumed to be part of cartel, even though not engaged in similar identical trade, provided the intention to participate in such agreement is apparent, or if they are found participating. What it means is that you have to show intention. You get my point? So that, and now in this same context, I'll explain you now this element of mens rea which has been brought in. Some of my friends who are lawyers here in this audience today would understand what mens rea is: knowledge and intention. Total mens rea has not been brought in. Only intention has been brought in. So element of mens rea has been included to safeguard alleged facilitator include trade association. Now, why it has been brought in is because it will also capture algorithmic driven collusions. There have been cases in the Western world where AIs have been found to be facilitating collusion on prices at least, right? So the AI driven collusions will be now captured by this provision, because facilitators will be caught only when they are. And I'll give you example of what is a hub and spoke cartel, since I said I'll be dealing with now. So indirect information exchange through a third party can amount to a anti-competitive agreement, provided there is a intention of that facility, of that third party to do so. I'll give you the example. There's a supplier B, and there is a retailer A, and there is a retailer C. So A supplies to B some material, and B supplies to C. Both are distributors of B. So B is the manufacturer, A and C are its distributors. So the rate what A gives, if that rate is known to supplier, and if the supplier passes that rate to C with the intention that the rate will be maintained by C, then it is a cartel. Then the supplier is acting as a hub, and A and C are spokes. I hope I'm clear. So that is known as resale price maintenance. What will happen is that if you want your price to be maintained by all your retailers, You are a manufacturer. Then you are actually facilitating a cartel-like coordination. Then it is illegal. Resale price maintenance is bad, is prohibited by law. So then the manufacturer or the supplier will act as a hub and the spokes will be. The best example is of the car dealers. The Hyundai case, the case of Maruti is also gone. Penalties have been imposed on them. They are in the appeals now. Hyundai, of course, won the appeal on some technical ground, but the point is that that's what they were doing. The discounts were being fixed. They were actually appointing mystery shoppers. At the dealer, they used to go to how much discount these dealers given. And if the dealers were given discount more than what was prescribed by internal policies of the companies, they were actually given notices. And even there were cases of dealership being terminated. So there are cases of, in the auto sector, there are plenty of cases where this kind of arrangements have been found by the CCI. But the relief which the law has given is, it will be only when the intention can be proved by evidence. Now I go to the next. I hope this is clear. Now the change in the vertical agreement also. So this has also is very interesting. So it has widened the net to include agreement other than vertical agreements between manufacturers and dealers. So all other agreement, including but not restricted to agreement between manufacturer and dealers, covered if they cause appreciable adverse effect on competition. Earlier, the position was that 5 categories of such vertical agreement were specifically named: tie-in sale, exclusive dealing arrangement, exclusive supply arrangement, resale price maintenance. Those are named into the section itself. But what the Act has done now is, it has included all kind of business agreement which are not included in those categories. So, for example, there could be agreement between companies which are not in vertical relationship at all, neither direct but nor horizontal, not vertical. So, I'm a manufacturer and he's not my dealer, but still I can have an agreement with a company which could be anti-competitive. So, those kind of agreements were going scot free. I give you the example of Hiranandani case. So, Hiranandani Hospital, had an agreement with stem cell, stem cell kind of the company which was storing the stem cells of newborn, babies, this thing which stems are, the cord is removed. So they insisted that if you go to a particular stem cell storer, then only you will be given the facility of prenatal facilities. So this lady says, how can you insist me? I can go to anybody. They said, no, we have an agreement with them. So this agreement was actually neither horizontal nor vertical. The business are different. Hiranandani Hospital was in a different business. This stem cell storer is totally different. So it is neither horizontal nor vertical, but still they had it. So they were actually caught. So these kind of cases will not be covered under this particular arrangement. And another categories of cases which are more particularly will be covered was, as I've said, more MFN clauses, the most favored nation clauses, non-compete clauses, parity clauses between the online travel agents, and you have examples of make my trip, Oyo cases, etc. That we can discuss if anybody wants to know. But those kind of cases will be covered. And then tie-in arrangement actually also been clarified. Service should be distinct product services, and even resale plus maintenance has been broadened to include any direct or indirect restriction on resale to dealers, not confined to price discount alone. So this is important. So resale price maintenance need not only be discount monitoring; it could be anything. It could be non-price also. So if you put a condition on your dealer or distributor that you cannot, you have to make a particular quality, for example, or delivery, etc., or you cannot areas of distribution are sort of fixed without that, or you even stop passive selling, etc. So those kind of issues will also not be covered under RPM. So basically, RPM has been broadened. So let me just share here. RPM is a practice which is very prevalent. People do it unknowingly. I'm sorry to say, we have got many cases, many queries come to us, and we have been telling companies that please be careful. RPM is actually is prohibited under the European jurisdiction. In the mature jurisdiction, RPM is per se illegal. Because if you are a manufacturer, after you sell your product, whatever price you sell, and there is a P2P transaction between your distributor, thereafter, what the price at which he sells or resales and where he gives into the market is his baby. You're not supposed to control that price. You are out of the picture once you manufacture and sell to the next in line. But if you try to maintain the price line or whatever, for whatever reason, it may come under RPM. I'm not saying it always comes. So that is the issue which I thought I'll just flag here. And then another issue is agreement between end consumers. So this will actually avoid unnecessary complaint by home buyers. In the case of real estate, actually it's to give relief to real estate sector, because after the DLF case of 2011, at least hundreds of complaints were received by the CCI against builders. And now who were the complainant were the consumers. The complainant were the buyers of those flats or allottees. So there was no direct relation of the, either horizontal agreement or vertical agreement. They were saying that we are, but they were not covered under Section 4 because they were not dominant. So Section 4, DLF was covered because DLF was held to be dominant in Gurgaon at that point of time. So that is why Section 4 will definitely cover unfair pricing or whatever, or discriminatory things, etc. But Section 3(4) is very specific. So now it has been clarified, the law has been codified that they and consumer will be excluded from 3 sections of Section 4. And there were cases, interesting cases, like Jyoti Sarup Arora, I was a party to that case. And so they basically, everybody was, booked in under 3(4), that it is not it may be a case of, vertical agreement, may even be a case of cartel, because all of your, buyer agreement are similar. So even we had seen those cases in good old days in 2012-13. And now I proceed to the procedural aspect. So this inquiry, how to inquire into anti-competitive agreement, there have been changes in that also. So introduction of a limitation for filing information or reference to CCI has been introduced. That means time limit of 3 years has been given. It is not that you can come after 5 year, 10 year, anytime you want, and go to CCI and knock at the door of the CCI that there is anti-competitive agreement. I've noticed there is a conduct which is anti-competitive, but there is a time limit has been prescribed now, 3 years, and it is in sync with the law of limitation. It has been proviso has been entered in 19(1). And actually, it will, to some extent, it will avoid filing delayed or vexatious complaints. There's no doubt about this. And then the factors of appreciable adverse effect on competition have been fine-tuned in the clause C and D of Section 19(3). I don't think I need to discuss them. You can read in the Act what the factors have been given. And 2 new factors have been added for determining relevant geographic markets, characteristic of goods or services, and switching cost. Similarly, 2 new factors have been added for determining what is relevant product market, switching costs, and categories of customers. Again, they are highly legalistic provisions. I mean, only the lawyers will be interested. And then similarly, this streamlining the procedure for inquiry under Section 19, that is under Section 26. So under 26, the principle of res judicata has been actually brought in by backdoor. That means no inquiry into repeated, allegation will take place. So this new concept of res judicata, no repeat inquiry in cases which have already been decided. So we had one interesting case I'll just like to share of a Hyundai dealer who came from Punjab, who came after the case of Hyundai was, under investigation and order was issued. So he had the similar problems of mystery shopping, and his dealership was also being terminated. We went and filed a complaint in the CCI. The CCI, they said that you have merits, but we will not entertain because we have already decided a case against Hyundai and penalties have been imposed on Hyundai on the same ground. So they closed our case. At that time, we had no recourse because they closed under a gray area because they didn't go even to the DG. It was a case of 26(2). And the complainant didn't want to go to appeal, although the appeal was provided under 26(2) cases. So now what has happened is they have provided rest.
Sharma, if I may interject here.
Yeah.
As a moderator, I think, unlike the audience, as a moderator, I have some right to interject as well. So, and thank you for
absolutely.
If in this Hyundai case, as a matter of curiosity, so since they decided against the principles and they levied some penalty, but if similar practice was again shown, there was another aggrieved party with similar practice, then why wouldn't the penalty be levied again? Why should res judicata be applied?
That is the point. That's what my critical appraisal will cover. I'm against this kind of principle.
Right.
We actually were very unhappy. We were very unhappy with this.
Right.
So why should you? That means that means that person will keep on doing. Once he has been penalized, he'll do it with others.
It's like saying that if you have been challaned once, then you can jump as many red lights as you want to. Then that's not
absolutely right. I completely agree with you. I would have said that in the end, but now that you said, you've taken words from me. So basically, it is not a very good res judicata should not apply to competition matters because these markets are very sensitive. That means you are disturbing the equilibrium of the competition in the market.
Understood.
Why should CCI not penalize again? Rather, that should be considered as aggravated case. It should be considered aggravated factor and heavy penalty should be imposed.
It's like a repeat offender. It's like a repeat offender. No, not
It's a repeat offender. It should have been like that only. But see, let me try to explain the legislature intention here is a repeated allegation under section 3 or section 4, which has already been decided in earlier case. So normally the jurisprudence so far grown on CCI is that they don't penalize again. I'll give the example of DLF. So DLF was in 2011 penalized with 700 crores, 670 crores. That's a huge amount. Now, several cases of filed against DLF after that also. It's not only Blair Association in Gurgaon which filed the case. They won the case, of course. Several trade associations filed the case, and the CCI said yes, they have abused dominance. They did not penalize them. No penalties were imposed. They were convicted under Section 4, but penalties were not imposed.
Right.
Because CCI also has a, has to see the industry concern. You can't keep on penalizing a company because he's doing fine. He has done once. Lesson has been learned. So that is, I'm being the devil's advocate here. The point is that is the purpose of putting this section, because why even an inquiry? Why even an inquiry when we can't penalize? That is the point why this amendment has brought in, and this section 22 has been imposed. So I am basically on the borderline side, though I principally agree with you, but there is a reason for doing that also.
Sure.
Okay.
So
let me proceed, sir.
As a time check, this is 1:14 by my watch. So I think although the Q&A has been is being taken in between only. So if you could still
I think you now, if you permit me to, because I have to say something in the end, you permit me to say that. I think people will like to hear me.
If you could try to wrap it in the next 10
I
minutes.
will wrap it faster. I'll be very fast now.
10
Let
minutes.
me be faster now. All right. So I'll be very faster. I'll just stress on slides which are more important. So this slide in the second area is DG has been in power to give supplemental, which already was there, but now the law has been codified. And there's a removal of ambiguity or gray areas on cases where CCI chooses to ignore finding. Now, this last bullet is important. There are a number of cases. There are a number of cases where there was no provision in the Act for the empowering the CCI to close a case where it did not agree with the DG. Let me explain the technicality here. So once a complaint is filed, CCI has to take a prima facie view whether they should intervene or not. Now, once they make a prima facie view, they refer it to DG. DG investigates. Now, DG report comes to the CCI. Now, DG report can two sides. It can either say there is a violation or it is no violation. In case of no violation, CCI will give the chance to the informant to come and file objections. But in cases where there is a violation found, but after the inquiry, after hearing the objections of the parties, CCI come to the point view that there actually no violation. So there was no provision in the Act to close that case. Understand? So what CCI used to do was, it was very abnormal. CCI is like a court of law. DG is like an investigator. Imagine the charge sheet being filed. Charge sheet saying in the criminal jurisprudence, charge sheet says there is an evidence, there is a violation. This person has committed murder, for example, and the court not being empowered to exonerate the accused if it finds that there is no case made out. It was that kind of a situation in the Competition Act. So that situation has now been cleared, and the section 26(9) has been introduced that CCI can even close those cases. And interestingly, there was no this was so gray area. There was no appeal possible under the against such orders. And CCI used to pass those within orders, so-called orders only. No section was mentioned because there was no section in the Act. And there were very interesting Jindal Steel and Steel Authority. Jindal Steel and Steel Authority case, I don't have time, otherwise I would have told you. And the Concord case of Indian Railways, abuse of dominance. The very interesting Jyoti Swarup Arora case. So there were cases which were actually there at that time. We were party to these cases. That's why I'm telling you, this is a very gray area. So now the law actually, thankfully, have been taken care. And now this another important is abuse of dominance. Now penalties on abuse of dominance, this one should note, has been actually enhanced. And global turnover has been reduced. This is very, very, in my personal view, very humbly, I would to say, it's a retrograde step. Because this step, and please read the bullet, though there is no change in maximum percentage or turnover of income up to which the penalties can be imposed, it remains 10% or maximum 3 times the profit for each continuous of a cartel, whichever is higher. But the turnover or income has now been specified. Turnover means global turnover derived from all the products and services by a person or enterprise. Now, here I'd like to take 1 minute or 1 or 2 minutes. See, this is this is a very debatable issue in the competition law jurisprudence. Initially, they were imposing penalties on relevant turnover. Then came a judgment of Excel crop in Supreme Court. Supreme Court said no, it is absolutely nonsense. That how can you impose a turnover, a penalty on the whole turnover when it's a multi-product company? There could be MNCs. The cartel has taken place only in one product, The other products are not under cartel or not. There is no allegation of any anti-competitive behavior there. How can you impose penalty on the total revenue, right, from all kind of products? So that thing was actually accepted by the Supreme Court, and Excel Crop case, in the Supreme Court said the turnover could only be on the relevant product on which the violation has been found. So that was known as relevant turnover. And this took place in sometime in 2017. So there was a lot of relief to the industry at that time. But now what has happened is surprisingly, I don't know how this has happened. The act says, now it's not regulation, it's the act which says the global turnover, not only total global turnover of MNCs. What will happen to the MNCs? What will happen to the big ticket, big digital tech companies? Just imagine. Google being penalized with global turnover, imagine. So the point is, just give an example, please don't get me wrong. Google is doing wonderful. We are so happy with Google. Without Google, we can't even function, in fact. So the point is, this concept of penalties actually on global turnover is also alien to the jurisprudence all over the world. Let me put it like this: that nowhere in the world, this kind of, to my knowledge, nowhere in the world this kind of concept of global turnover exists, because there are codified regulations in the European Union as well in the United States, which are the two hubs of antitrust. They are the mothers of antitrust, I so to say. US is, of course, the mother of antitrust. So they have actually quite detailed guidelines that, and that is actually degree of proportionality is taken care. So the penalty has to be proportionate to the offense committed. It cannot be disproportionate. But this global turnover actually is bringing it back, taking it backwards. So we have gone back to before 2017 now, and that's very unfortunate. I know why it has happened. I have no idea, because this has happened in the Lok Sabha, Rajya Sabha. It is not something which is recommended, to my knowledge, in the Parliamentary Standing Committee also.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.